Hello, Carla Hartley here. Today I'm starting a new series, and this series of short videos is going to be on how to save yourself money, or the corollary, not to cost yourself additional money in a family law proceeding. In family law proceedings, there is an affirmative duty to disclose your financial information to the other party. This, when I say it is an affirmative duty, that means it is an obligation that is imposed by law on you to volunteer this information. There are certain forms that are required for you to fill out and then serve to the other side. When you have an attorney, it is our job as an officer of the court and as a reputable family law attorney to not play hide the ball. So the first thing you have to understand in this concept of not costing yourself money in the disclosure process is this is not like TV law. It is not like criminal law, and it is not like other areas of civil law. You see a lot of stuff on TV about, hiding the basic evidence, hiding the ball. That is specifically dealt with in our statutes and our case authority that will impose significant financial sanctions on you for failure to disclose certain financial items and pretty much anything, any asset or debt in which either party may have an interest or a liability. Your income flows, your income streams, all of this is before the court. Your best method of saving yourself money is when your attorney calls and says, hey, I need this, give it to us. And if we have not been clear enough in our request, you should ask, is there anything else? We are going to be very clear in ours. I don't know how all other attorneys do it. I know that we have a form that we have created that's many pages long that asks a series of questions. Is real property at issue in your case? If it is, great. If it's not, let us know. And the client goes through and checks these boxes off. If real property is at issue, then we take the next step, and we want to have the documents concerning the real property. Same, there is or is not a business. There is or is not banking accounts. There are or are not banking accounts, to be grammatically correct. So that's how we handle it, so that when we get down to the line, if there's something that's been hidden, we can pull out this piece of paper that says, not malpractice, our client told us we could rely on this, and the client signs that document. Going through that document in a timely fashion, going through anything that your attorney asks you to do with regard to your obligation for disclosure, and answering their questions honestly is the first best way to save yourself money. Now, if you make us chase you for the information, an attorney's time, any attorney's time, is their inventory. Their only inventory is their time. So every time that attorney is calling you, or the paralegal is calling you and saying, hey, I need this information, you may be being billed for it. And certainly once a client becomes particularly evasive and it's taking a lot of our time to chase the client, we do start billing for that. Some attorneys bill as soon as they have to make the first call. Some wait a while before they discover the client's going to be difficult before starting to really annotate those charges. Making us chase you for documents is a problem. Making us chase you for responses is a problem that will cost you money. And trickling in your documents is a tremendous time consumer for an attorney's office, and it will cost you a lot of money. For instance, if your obligation of disclosure says that you need to provide us with the statements for your mortgage, and you give us one sheet for your mortgage statement, but it clearly says that it's a 4-page mortgage statement. We need the 4 pages. That is what we are obligated to produce. And if we've asked for 20 documents and you produce 2, and then we have to call you about the other 18 and you produce 2 more, what you need to realize is we're inventorying every time we return to this file. We're inventorying what we have, double checking what we don't have. This runs up your bill. Now, there is a fundamental principle in the law in our nation, And that principle is that you should be able to participate in your own case. In family law proceedings, the more effectively you participate as a team member with your attorney, the less your bill will be. That is not guaranteeing that you're not going to have a hotly contested case. That's not guaranteeing that you're going to get out paying nothing. In fact, if you have an attorney, you're paying something. But what it does do is it mitigates the cost of your case. And here's the other cost that working as a teammate with your attorney will save you. It is an emotional and psychological cost that you will feel out of control of your case if you are not participating in it. If you are not actively cooperating with your team, the people, your advocates, we're on your team. If you're not cooperating with us and you're fighting with us, it's going to cause anxiety and it's going to cause a degree of resentment. So the emotional, psychological cost of this needs to be added to the financial cost. And I think all of that can be alleviated if you take the time to talk to your attorney or their paralegal, if they've got an experienced paralegal, and find out what they need. The attorney should be telling you, the paralegal should be telling you. If you don't understand, have that discussion and feel like you're a participant. You should feel like you are a participant in your case. It is a lawsuit. You are the best person to have an attorney access for information on your own case. This saves you a lot of money and it saves you a lot of emotional and psychological stress. That's my hot tip for today. I will resume this series next week with a further discussion of how to save money or not cost yourself money in your family law proceeding. Thank you.